Good day, Crime Talk aficionados. This is the weekly recap where you will see all of the top stories throughout the week, conveniently located in one location. So don't tell me, hey, I've seen this. It's a recap. But if you haven't seen it all week, it's a great place to get the top videos throughout the week. Hope you enjoy it. We'll see you on Monday. And remember, the Constitution matters.
All right, lawyer.
Next on the docket, Karen Read. So the director of the documentary on the Karen Read case, Monday stated that he had unprecedented access, and his film crew did as well, to the former financial analyst and her high-powered legal team during the buildup to Karen Read's first trial for allegedly killing her boyfriend in a drunken driving case, right? Anyway, it's a Vallow documentary. The director says, Dunn Muir, who helmed A Body in the Snow, the trial of Karen Read. It's a 3-part series premiering March 17th. So get ready, I guess. And anyway, following someone throughout their trial is very unusual. The director noted, he says the access is unprecedented and that we had Karen and her defense team. It was a little surprising and a great opportunity to be able to them to go through the process. Anyway, they also noted it's very unusual for somebody to have access to the defense team so they think they have something important for everybody to share. Anyway, this 3-part series is set to air on the Investigation Discovery Network on March 17th, 18th, and 19th. It'll also stream on Max. I'm always a little uncertain about this. And full disclosure, I had something like this done years and years ago. It was a child abuse resulting in death case, and it was something called In the Jury Room. But everybody got permission. The producers, it was done by ABC, followed the prosecution. They followed the defense. And in that particular case, they actually videotaped the jury deliberation process. We got the approval from the Colorado Supreme Court. I believe they did it in at least one other state as well. But once again, you had approval from the Colorado or the Supreme Court in that particular state. So, talking to the press always makes me uneasy. And my biggest thought during that process was like I said, it was a bad case. Child abuse resulting in death. My client was found guilty of a misdemeanor. It worked out well for my client. But had we lost, I could see the post-conviction matters. Oh, the attorney was just showboating. He's revealing attorney-client privileges. I mean, anything you could possibly come up with if it doesn't go well. And here, the client, anything she says will be used against her. So if she says something in that video that is maybe contradictory or an admission about her involvement in that particular case, obviously, it could be really, really bad. I think it's better just not to do things like that. And having done that, I think it's better. Looking back, hindsight, 20 years later, it's probably just better. Anyway, the judge presiding over the Karen Read case on Friday denied the defense request to add a 5th lawyer to the Karen Read defense team. In a brief ruling, the judge said Read's lawyers cannot add New York attorney Mark Betterow to their ranks. The judge denied the request in part because Betterow also represents Aidan Kearney, the blogger known as Turtle Boy, who's charged with harassing and intimidating witnesses in the Karen Read case. The judge said that amounts to a conflict of interest, and that is not waivable under the state attorney rules. I totally agree. In seeking to add Mr. Betterow to Read's defense, Read's attorneys David Yannetti said in an affidavit that Betterow promises to restrict his use of certain information, and the judge says, no, you can't do that. It's very hard to build what they refer to as a Chinese wall around an attorney and say, you can be on the case, but you're not going to get this information. And then don't use that information, what you learn here, in your case. Doesn't really work. Very hard to do. Just not worth the problem. Anyway, the clear inference of the promise is that Mr. Betterow would not use protected information gained in the representation of one client for the purpose of representation of the other client, the judge noted in her order. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit the second client. That's untenable, the judge noted. The court cannot permit such a conflicted representation and declines to add the defense team that currently numbers at least 4 lawyers. Now, obviously, Ms. Reed has pled not guilty to the charge of second-degree murder, manslaughter, while operating under the influence and leaving the scene of a crash resulting in death. Now, prosecutors allege that she backed her Lexus SUV in a drunken rage into her boyfriend, Boston police officer John O'Keefe, early morning hours of January 29, 2022, after dropping him off outside a Canton home, followed by a night of bar hopping. Her lawyers say that she was framed and that O'Keefe entered the house owned by, at the time, a fellow Boston police officer, where he was fatally beaten and possibly attacked by a German Shepherd before his body was planted on the front lawn. Now, Reed's trial is scheduled to begin on April 1st after the first trial resulted in a mistrial back in July of 2024. Now, Mr. Kearney, Turtle Boy, has aggressively championed Miss Reed's innocence and helped spark the national interest in her case. His lawyers say his actions that authorities are calling criminal harassment were legitimate acts of investigative journalism and advocacy protected under the First Amendment. Now, back in January 2024, authorities alleged that Miss Reed had been orchestrating Mr. Kearney's coverage and sharing non-public information about her case with him. And records indicate that Kearney and Reed had 189 phone calls over 7 months back in 2023. The judge issued another order that limits what lawyers in the case can say about the matter when they're outside of the courtroom. The gag order issued last week was requested by prosecutors who have accused Reed's defense team of violating the protective orders in court's rules. Now, the decision by the judge instructs lawyers on both sides not to release information that could potentially prejudice the legal process or influence the trial's outcome, according to the order. Standard kind of rules when it comes to attorneys. Now, like I said, I think the court can limit the attorneys from saying things that are going to dissuade or prejudice a particular side in the case. But I think we, as the public, should be able to get the information and make our own decisions about it. The judge's restrictions cover information that is protected by court orders or could prejudice potential jurors or witnesses, and the lawyers are also prohibited from publicly disclosing evidence that is unlikely to be admitted at trial. Seems fair. Go try this case in the courtroom. Okay. Now, over the weekend, I was able to take a little bit of time off, and I went deep into a lot of bloggers and other people, say, for example, on X and things of that nature. There are definitely 2 camps out there. Karen Reed has been framed. She's completely innocent. And then obviously Karen Reed is guilty camp. I think most of the people there are absolutely reasonable. Okay. And like I said, the first trial, I probably would have said not guilty. It was just weird the way the whole trial came about. I don't think the prosecutors were particularly great. And I think there was some reasonable doubt, obviously evidenced by the fact that it was a hung jury and they couldn't ultimately reach a decision. Now, I understand the whole, did they meet your decision? No, it doesn't matter until it's officially out there. All right. But let me just be realistic. And some people are going to say, oh, Scott, you're falling into one particular camp or you're not. Let's have the trial. Okay. And I know, okay, everybody loves a good conspiracy, but like lots of things in life, it doesn't matter what you think or what you believe. It only matters what you can prove. And that really what it comes down in court. And I watched all the video this weekend of, was the taillight broken when the car goes to the impound? It looks like it was broken. And we also had the juror from the previous case that said, well, we really didn't see the whole conspiracy to frame her thing. I think that's a little bit of a stretch. And don't get me wrong, I've had lots of cases where I thought, man, this is going to be great. These cops did this and they did that. It's tough really to prove. And generally, most people hold police officers in general high regard. So, and second time around, I keep telling you this, ladies and gentlemen, second time around is not doing Karen Reed any favors. The defense had their shot. The prosecution is fixing their case. They have a much more competent prosecutor, former or defense attorney, back to prosecutor, going after this case. I just, we're going to have to wait and see. I'll give everybody the presumption of innocence. We're going to have to wait and see. But I am a realist, ladies and gentlemen, and any good defense attorney that's going to be intellectually honest is always looking at the facts of the case. And I've had cases that I thought this is going to be a great case. And then we learn some new facts and the case turns to absolute garbage. And that's the way you have to be. You can't ignore the bad facts. You learn that in debate, you learn that in law school, and you certainly lose that in trial. If you can't either embrace or explain the bad facts, it's going to get ugly. And the defendant's going to crash and burn, and it's not going to be pretty. Lori Vallow. That's right. Lori Vallow doing her lawyering thing pro se. Now, she didn't have a great day in court today. In fact, the judge ruled against her on several of her motions. Now, for those who are not familiar, Lori Vallow has 2 cases pending in Arizona. All right. The first case that's going to go to trial first is the conspiracy to commit the murder of Charles Vallow. It is alleged that back on July 11th of 2019, Charles Vallow, Lori Vallow's 4th husband, was shot and killed by her brother Alex Cox in Chandler, Arizona. And Cox claimed self-defense, stating that Charles attacked him with a baseball bat during an argument at Lori's home. No charges were filed against Cox at the time, and he died of natural causes, a blood clot, in December of 2019. Now, the prosecutors allege that Lori conspired with Cox to murder Charles as part of a broader scheme to remove obstacles to her relationship with Chad Daybell, husband number 5. Now, at the time of his death, Charles had filed for divorce in February of 2019, citing Lori's increasingly erratic behavior, including her claims of being a godlike figure tasked with ushering in a biblical apocalypse. He had also obtained a restraining order against Lori after she allegedly threatened to kill him. Now, prosecutors argue that the killing was premeditated, motivated by financial gain, a life insurance policy, and Lori's desire to marry Chad Daybell, whom she wed shortly after Tammy Daybell's death in October of 2019. So specific evidence details are somewhat limited, obviously, from what we know thus far, but the indictment from 2021 suggests prosecutors will rely on circumstantial evidence, such as Lori's communications with Cox and Daybell, her actions following Charles' death, for example, moving to Idaho, and the timing of subsequent events tied to her doomsday ideology. Her second case that is scheduled to go second, and Lori says speedy trial issues are running on this particular case, but the judge says not worry about speedy trial because I can't try both of these cases at the same time. So at the hearing today, obviously Lori remains in custody, and she is still classified as a high security inmate. Now she spends her time actively preparing for trial, representing herself, and challenging the prosecution's case. As of today, March 11th, 2025, Lori Vallow appeared in the Maricopa County Superior Court in Phoenix for a pretrial hearing ahead of her upcoming trial on the conspiracy to commit murder on her 4th husband, Charles Vallow. The hearing is about 20 days before the jury selection begins. It's scheduled to start on March 31st, 2025, and it was focused on several procedural matters as Lori Vallow prepares to represent herself at trial. What could possibly go wrong? What do they say? He who represents himself has a fool for a client. Well, a central issue was the presence of cameras in the courtroom, and the Judge Boreski, ruled that a single pool camera would be allowed to live stream the trial with a possible 1 or 2 minute delay, despite Lori Vallow's objections. She had previously filed a motion to ban cameras, citing concerns over media portrayal, such as court TV commercials she claimed to misrepresent her and her husband, Chad Daybell. Now, during the hearing, she expressed specific worries about cameras zooming in on her notes or her face excessively, requesting that coverage focus on the judge or the prosecution when they spoke. The judge assured the guidelines would be issued and forthcoming, and they would address all of Lori Vallow's concern. Another point of discussion today involved evidentiary matters. Lori Vallow argued for the admissibility of a police interview with her late brother, Alex Cox, the alleged shooter in the Charles Vallow case, claiming it didn't constitute hearsay because it wasn't offered for the truth of the matter asserted. The judge challenged her reasoning, asking if she wasn't implying the statements were true, to which she responded ambiguously, saying she couldn't confirm their veracity. This exchange highlighted her active engagement in legal arguments as her own counsel, supported by two advisory attorneys, Pamela Hicks and Robert Abernathy. Now, the hearing also touched on jury selection logistics. The judge outlined that 200 potential jurors from Maricopa County would soon receive electronic questionnaires with responses reviewed by both sides to narrow down potential jurors. Additional questionnaires could be sent out if needed, and in-person questioning is set to begin for the 12 jurors plus 3 to 4 alternates. That questioning will begin in early April, and opening statements are expected around April 7th, with the trial lasting up to 6 weeks. I can't believe it's going to take 6 weeks. It's like a 6-day trial anywhere else. Anyway, this hearing underscores Lori Vallow's legal battles in Arizona, where she faces charges tied to the 2019 shooting of Charles Vallow and a separate conspiracy charge for the October 2019 attempted murder of Brandon Boudreaux, her niece's ex-husband. Already convicted in Idaho of murdering her children and conspiring in Tammy Daybell's death, she remains a high-profile figure, with today's proceedings reflecting both her self-representation strategy and the court's efforts to balance the public access with the trial fairness. Her next court date is March 18th to address some additional issues. Now, Lori has also done some filings in her cases, and it is the Defendant's Supplemental Rule 15.2 Notice of Defenses and Disclosure. You must, in a criminal case, disclose any defenses to the court and to the prosecution, usually no later than 35 days before trial, so that you can, everybody's on notice and it's a fair trial. Just like in the Kohberger case, they have to give their alibi up front because we don't want to prosecute an innocent person, right? Exactly. So you have to put everybody on notice. It's just the fair and right thing to do. Now, remember, Lori Vallow is charged with conspiracy. Conspiracy, which is an agreement between two or more people to commit an illegal act. And the defense to the conspiracy is there is no conspiracy. That's what you have to be able to show. Judge, I didn't conspire, and therefore I cannot be held responsible for the acts of another. They acted alone. So you would say general denial. And if there was, in fact, a conspiracy, the only other defense that you have that there was no conspiracy was, I was in the conspiracy, but I withdrew from the conspiracy and I shouted it from the mountaintops and said, I will not be involved in the death of Charles Vallow. I'm not aware of any of that. So really, the only defense is general denial, no conspiracy. Her opening statement should be, ladies and gentlemen, I have been wrongfully accused of a crime that I did not commit. There was no conspiracy. I didn't know my brother was going to kill Charles Vallow, my fourth husband, who, although we had our issues, I loved dearly, and I would never harm him in any way. What you'll hear is speculation and rumor on behalf of the prosecution witnesses, but they were not there. They don't know what took place in that house, but all we know is that I wasn't there and there was no conspiracy. And ladies and gentlemen, when you hear all the evidence in the case, you will conclude that there was no conspiracy either and find me, Lori Vallow, not guilty. That's all she has to say. Brian Kohberger says the real killer must have planted the knife sheath recovered from the crime scene, and it could have been planted by the real killer. That's right. That's what were able to glean from some recent filings in the Kohberger matter. Now, for those who aren't familiar with the Brian Kohberger matter, he's accused of fatally stabbing Madison Mogen, Kaylee Gonzalez, Zaina Kernodle, and Ethan Chapin at their off-campus home there in Moscow, Idaho, back in November of 2022. Brian Kohberger pled not guilty. His trial is scheduled to begin in August, and if convicted, he faces the possibility of the death penalty. Now, in a filing released late Tuesday afternoon, we talked about this last night, prosecutors summarized a defense filing that appears to be sealed, and instead of challenging the conclusion that the DNA on the knife sheath belonged to the defendant, the defense expert disclosure reveals that the defense plans to argue that the DNA on the knife sheath does not prove Mr. Kohberger was even at the scene of the crime, and that the real perpetrator may have planted the knife sheath himself. Now, the prosecutor's motion quotes a defense expert disclosure that prosecutors say reveals Kohberger's lawyers intend to call an expert in forensic biology and DNA who will testify that there is good support that Mr. Kohberger's DNA was found on item 1.1, and that's from the swab of the knife sheath, but no further information from the defense expert disclosure is provided in the prosecution's filing, which was dated March 10th, which was just yesterday. Like we talked about it on our live show last night. We talked about how the defense was not going to argue the IgG faults and that the DNA testing must be faulty in some way. No. All right. So anyway, the DNA recovered on the button of the knife sheath ultimately led investigators to Brian Kohberger. That's right. It's a key piece of evidence. And that issue has been the subject of a lot of pretrial litigation. Anyway, the Idaho State Lab first located the single source of male DNA left on the button snap of the knife sheath found on the bed next to Mogen's body. Police used investigative genetic genealogy, or IgG, with the FBI. And the IgG is a field of forensic science combining DNA analysis with genealogical research to connect the sample to Brian Kohberger's family. Now, investigators then went to Kohberger's family home in Pennsylvania and pulled items from the family trash to test against the knife sheath sample. Now, the DNA profile obtained from the trash was identified as not being excluded as the biological father of the suspected knife profile found on the sheath. Now, a cheek swab was then obtained from Brian Kohberger, and they were able to confirm that he was a statistical match to the knife sheath sample. Now, Brian Kohberger's defense team has repeatedly questioned the use, legality, and accuracy of the DNA testing done at each step of the process throughout this trial. Anyway, the potential defense strategy comes in a filing from the Idaho State prosecutors saying they're willing to agree with the defense position to exclude the trial evidence related to the genetic genealogy. Now, prosecutors say they only plan to refer to the IgG materials as a generic tip without revealing the tip's source or substance, according to the filing. And they'll ask the investigator on the stand to testify that law enforcement simply received a tip and that based upon that information, other evidence was developed, and it ultimately led to Brian Kohberger being identified as a possible suspect. We brought it to you last night, ladies and gentlemen. That was they can't explain away the DNA, so they got to embrace it. They got to embrace it. It's there, but we don't know how it got there. We know there's these other DNAs outside, right? The real killer must have done it and planted it to cover their tracks. And obviously, let's take advantage of the kid with autism who is kind of socially awkward. We'll blame it on him. That's the theory, ladies and gentlemen. Richard Allen. That's right, the Delphi homicide murderer. Attorneys for Richard Allen, obviously the man who was found guilty of murdering the Delphi teens, Abby Williams and Libby German, have filed their notice of appeal in regards to his convictions and released key evidence in the case. Now, obviously, Richard Allen was found guilty last year of murdering the girls on February 13th of 2017. Now, following his conviction, he was sentenced to 130 years in prison, which is the maximum sentence allowed under Indiana law. Now, the March 11th filing comes a little over a month after Allen's attorney submitted a motion to correct errors. The motion details 4 alleged missteps that the defense feels are significant to warrant overturning the jury's conviction and having a new trial. Allen's defense team expressed frustration over the trial's proceedings and their belief that the girl's killer or killers remains free. Now, defense attorneys Jennifer Auger and Andrew Baldwin believe crucial third-party evidence, which they argue could have exonerated Richard Allen, was excluded from the trial. Judge Francis C. Gull ruled there was no link between the suspects the defense wanted to bring to the jury's attention. Now, the jury wanted to convict someone, the attorneys argued. They feel that that is their job. And with no one else to point the finger to, the defense attorneys believe that had their third-party evidence come out, that the outcome would have been completely different. We'll have to wait and see as it relates to how things go on the appeal. That ought to take a year or two. It's going to get interesting. But the big news of the day. Now, this comes from the Justice for Rick Allen website, all right? And they're apparently Transparency and Justice, as they refer to it as. So the attorneys that representing Mr. Allen continue to receive considerable and number of inquiries and requests for access to public records and exhibits related to the state of Indiana versus Richard Allen. In response to similar requests, the court has stated that the exhibits are needed for the production of transcripts if the parties request one, and that fulfilling such requests will interrupt the process of guaranteeing the court reporter will be forced to ask the Indiana Court of Appeals for an extension of time to complete the transcript. Recognizing this significant public interest and in the spirit of transparency, this website is going to serve as a central resource for accessing public records, exhibits, frequently asked questions, and updates on Mr. Allen's post-conviction legal proceedings. And all information is going to be provided, according to this website, in accordance with the Indiana Rules of Access to Court Records and the Indiana State Code 5-14-3. And here it is, all 43 seconds, raw video, 43 seconds obtained directly via the extraction performed on Libby German's iPhone. And this was an iPhone 6, and that was done by Sergeant Brian Bunner on February 15th of 2017. Now, what you will notice is that 11 seconds into this video, that's when you see the mail come into view. Then everything goes quiet. And 37 seconds shows where they would have basically gone down the hill. Probably the last portion of that video, or moments later, where these girls would have been killed. Now, here's the interesting thing. When you look at that video, the bridge guy video, you can't really make out who that is. But remember, Richard Allen went and said, "I was out there that day," which goes back to my point that I've said many, many times on this case. It is always the defendant's own words that get them in the end. Next on the docket, Lori Vallow. She believes that the prosecutors are playing dirty. Why do you say she thinks they're playing dirty? Well, she is filing a motion objecting to a witness in the case, a now retired detective, a detective Daniel Coons of the Chandler Police Department. He was there at the scene that day, and the police have endorsed him as an expert witness just a mere couple of weeks before trial, and that's not going to give her sufficient time in which to get a new expert to rebut Daniel Coons. And now what Lori Vallow is saying is, guess what? That guy, he's not an expert. Remember, ladies and gentlemen, what is an expert under 702? Somebody that has some specialized training and knowledge. That's right. So Lori Vallow says Detective Coons' opinion as a detective would not be admissible at trial, generally so. So the state is now naming him as an expert to give him his opinion in front of the jury. Now, the CV, fancy word for resume, attesting to the expert's qualification has not been made available to the defense, nor has the defense interview occurred. For over a year, Detective Coon has been limited as a witness and not an expert. And noticing an expert allows the defense the opportunity to recruit a rebuttal expert. However, the absurdity of the timing of the disclosure now turned expert violates due process rights. This is not sufficient notice, enough time to locate an expert, request funding through the courts, and have the expert perform their own analysis and complete a report. And obviously be prepared and be able to show up and testify at trial. This is just downright dirty. Well, Ms. Vallow, I guess the court could strike the detective as an expert witness, but it seems as though the disclosure was made within the allotted time. So that wouldn't necessarily be a basis. But what would the remedy be? You could strike it, but that's an extreme remedy, if it's assuming it's all timely. Your remedy is a continuance to try and find an expert. But then you have to find an expert that you think is going to disagree with the prosecution's expert. And there you go. There you go. I don't think you want to waive speedy trial. Remember that, Ms. Val? That's why you're proceeding on your own, pro se. Oh, the tangled webs we weave when we try to play lawyer. Good luck, Lori. Good luck. You're going to need it.